Discussion, with a brief introduction. I might start with myself and pass on the baton. I'm a survivor of 30 years of domestic violence and 4 years and counting of post-separation and systems abuse. And I'm passionate about change and real action. We hear a lot of discussion. Um, we're ready for movement and change. So that's the reason we're here tonight with these amazing advocates who work tirelessly in this area of domestic violence and coercive control and perpetrator accountability. And I would love for us to talk about the deep systemic change that we need to see happening, as well as community change in the community, in our culture. So I'd love to firstly introduce Betty Taylor of the Red Rose Foundation and the Australian Strangulation Trauma Centre. Betty, could you tell us a little bit about yourself and your amazing work?
Thank you, Janine. It's a pleasure to be here. I also start by acknowledging the traditional owners on the land on which we're gathered and pay my respects to their owners, past, present and emerging. I've worked in domestic violence now for over 34 years. And while we see in that time we've had some amazing gains, in some ways we've actually not got that far at all. When we look at, there's more services than ever before, but victims remain really at such high risk. The homicide rates aren't really moving much, and we work in that area of high risk, high harm. So I'm the CEO of the Red Rose Foundation. If you want to know more about that, have a look at our website at theredrosefoundation.com.au. Probably now almost 20 years, since 2004, we've been lobbying to get non-lethal strangulation as an issue in Australia, and recognising it is one of the highest risk indicators to homicide. We were successful in Queensland of being the first state to get specific legislation, but that wasn't the end of it. We stepped out and recognising victims need specialist support, and we've established now Australia's only strangulation trauma centre. So I'll talk a bit more about that later, but thank you for now.
Thanks, Betty. And Ruth Stearns Mandel, it's very early where you are. Tell us where you are and tell us more about your amazing work too.
Well, I also want to honor the traditional owners of the land, which here in Connecticut and on the land that I am on right now is the Tunxis tribe. And I want to acknowledge that I am on stolen land and that reparations still need to be made to the traditional owners of the land. And I work with Safe and Together Institute and my partner, David Mandel, who has been in the domestic violence field for a long time. I'm a survivor, and he was the only person who could inspire me to step into this space as a survivor of child abuse and domestic violence and coercive control, and really felt the urgency of working with systems who we are told to engage as survivors to seek safety. And having experienced those systems as a survivor and their responses, most survivors know that those systems are siloed and fail them in some way, and that much practice is hinged upon principles which are gender biased from the beginning, and very limited interventions and understanding of domestic violence and coercive control. And that up until this point, and even at this point, most organizations work from a failure to protect lens with a violent incident lens, and are often incapable of looking at a pattern of behaviors, which is what we need to look at when we look at coercive control, and are often not contextual enough to understand power and control and vulnerabilities of survivors, and how abusers use and manipulate those vulnerabilities and the system's own vulnerabilities in order to continue their coercive control and harm of us. So really happy to be here with you all, and extremely grateful that you invited me.
Thank you. Thanks for joining us, Ruth, and Betty. And we've got Jane Matz as well, of the Sisters-in-Law Project. Jane, we've just had a little introduction from everybody to tell us a little bit about themselves and their work. So amazing work going on, and please share what you're up to.
Okay, thanks for that, Janine. The Sisters-in-Law Project we actually started because we have such a significant problem in the way domestic violence and child sex abuse is managed within the family court. And in fact, a lot of women have come forward and asked for some more support to be able to manage some of the things that they find are unbelievable. In particular, the setting aside of protection orders, the fact that they're following state guidelines to be a protective parent. And in that process of doing so, the court actually sees that they are a problem to the relationship rather than doing what is required by the state. And I think that as far as legal aid and legal support is concerned, there is a minimising and a push for co-parenting within the family law environment that is unsafe and very much a problem within not just Australia, but internationally. And I'm sure that Ruth will cover that with some of the things that she's seen over the years. But I must say that I do from time to time see some shift and see some change in relation to better management of domestic violence, but there are still some terrible cases out there. So the Sisters-in-Law, we provide support, Sister-in-Law Project. We do it on a project basis. So we look at systemic issues. We look at if we're going to help someone, how do we bundle all the tasks up into something that's like a project? And we work really closely with lawyers. We do timelines, we do evidence lists, we do facts lists, we look at what their key arguments are within the process, and we look at how the scheduling of those the case will be within the court, and if we can find ways to get out of litigation, because it really isn't good for anyone, and it certainly isn't good for children. So there's 23 of us at the moment that are doing a lot of work with sisters. We have over 230 contacts in relation to the website that we've just recently soft launched, so it's not formally launched. So once we do formally launch in November, I'm sure there'll be a lot more that we'll be assisting others with.
Thanks, Jane. And I just wanted to let everyone watching know that we're live streaming, and there's a Q&A chat box where you can send through questions, and we'll be we want this to be a very interactive evening. We want your questions and feedback, please, so feel safe and comfortable to share, to join in the conversation. I think from everyone's introductions, something that springs to mind that I hear a lot from survivors is this statement: it's not safe to stay and it's not safe to leave. And I think a lot of people just don't understand the dynamics of coercive control. And even when you're a victim, it's very confusing. That's what I hear from most of the survivors. They just didn't know what they were involved in, and they didn't understand the manipulation. And Ruth used that word before too. So maybe we could start off with a bit of a definition of coercive control. I understand it to be all about power and control, having power over someone, and that it's a choice. It's not the behaviours are. It's a behaviour choice to control and abuse your partner, and other words that I often use are sabotage and well, coercion, of course, but humiliation and really the ownership and possession of the partner becomes all consuming. So I wonder if we could talk to what is coercive control, the physical and non-physical elements of coercive control. Maybe Betty, would you like to start?
Yeah, happy to. Just I saw in the chat box a reminder from CJ, thank you, that if this is triggering for people, she's dropped some phone numbers in there so people, take self-care and reach out if you need to.
Thank you.
There's a lot of talk at the moment about coercive control, and people would have read that Queensland is now moving to criminalise coercive control. It's not new. We've had an understanding of this for many years. As I said, I've worked across this for 34 years. We go back to the work from the amazing Ellen Pence, who developed the Power and Control Wheel, Evan Stark, who's also done this work. And I think we need to broaden our understanding. People talk about it as like a shopping list. Does he go through the phone? Does he, ban your friends, control what you wear? It's more than that. I think that it is the platform of which all other forms of abuse springboard. It's the essence of it that sits at the base of domestic violence. And without it, if we don't have power and control, we're not talking about domestic violence. But what's not understood is that when we're talking about it as well, is I call it their modus operandi. They use it against everybody. It's not just their partners. So when they're entering into the court system or the police system, that's what they operate out of. So they are convincing people that they're the victim. They're the victim in all of this. And they will, if people really don't understand power and control dynamics, they will get caught up in it really easily. So the mind games that he plays both with his victim, he will act that out. So an example that we might see is he's telling her, you're crazy, you're stupid, I don't have to go around hitting anyone else, it's all about you. Then he will mirror that and play that out to the police or to doctors. She should be committed. And we've had women that have ended up in the mental health ward because people have acted out, believing what they're told. And so we had that program that was launched during Sexual Violence Prevention Month, Start by Believing. And I think that when we apply that to coercive control, what's at the base of it is, Janine, is really looking at not just all the ways a woman may be controlled by their partner, but what's the end result. And I always talk about a relationship that has a rule maker and a rule breaker. So the person that makes all of the rules, this is where you can go, this is where you can see, this is when you have to be home, there will always be a rule breaker. And so what the rule maker then can do is feel very justified in meting out punishments. You weren't home when I told you you had to be home. You're doing things that I told you not to. You spend too much money. So women start to live in fear of all these rules. They're living in fear of breaking the rules. So when we're working with survivors of domestic violence, we've got to be really careful that we're not just looking at all the things that he can do, but it's about those rules. And just probably last comment on it is, it's not the coercive control in itself that leads to a homicide. It's the loss of power and control. So when they start to see that power and control slipping away from them, it's very dangerous. And we talked about when women start to leave. And separation, oh, hello, we've got a beautiful cat joined us. When women make that decision to leave, that's where most homicides will occur, either in post-separation or in the act of separating. And that's really about the loss of control. They will try anything and initially to get that power back, that control back. I'll go to counselling, I'm never going to hit you again, we're never going to do this again. They'll look at the revenge, and finally then it'll lead to serious violence and homicide. So, that's acted out through all the mediums of the courts, the police, service providers, and that's what I think people don't understand. It's not just power and control, it's the absolute loss of it. And if we don't grapple with that before we bring in legislation, I have a fear we will see far too many victims of domestic violence also charged with it.
Yeah, I agree. And I think I hear a lot of survivors say if they knew, they thought leaving would be the hardest part. And if they knew what the post-separation abuse would entail, many have said they would have stayed because the post-separation abuse is so horrific. Ruth, what were your thoughts? Do you have more to add to Betty's very clear explanation?
Well, there's so many different experiences of coercive control, and they're all very culturally specific as well. For example, as a woman who's Latina and also gay, my vulnerabilities are going to be different than somebody who's Black or who is of another ethnic group or is from a marginalized group such as Aboriginal people who are already challenged in the system by systemic racism. And that one of the things that's important for us to remember is that when the laws were formed and the legal structures that we engage were created, we were property. That is the reference of the law. And you cannot pull out that reality at this moment from how the law engages women in these proceedings, including divorce proceedings. The family court system was set up to divide property, not to protect children. And it is really important that we remember those reference points and that we demand reform and we demand that those institutions shift to not just look at us as property, but see us as individual humans with human rights and the ability for us to leave relationships safely. We all have a foundational right to leave a relationship safely without being threatened with violence, without being threatened with financial ruin, and without being threatened with taking our children away. And that, as Betty said, this is about power and control, which is why any tool at the disposal of an abuser is one that they will use, especially if it's the government that will mandate to us or a court that we comply with this person's demands. And that, yes, our gender double standards do play into that. We still view women as the primary caretakers responsible for the well-being of children. And we do not consider men or fathers as being nurturing, as being emotional caretakers. And that is absolutely wrong of us. It's an injustice to our children. It's an injustice to men, and it's an injustice to women and our families. So I feel like it's really important to remember that these institutions are adversarial to us, number one. And I think that it's important to remember that there is no singular solution, that we all have to work together with the knowledge that perpetrators with power and control and money are constantly lobbying to neutralize our efforts to make our children and ourselves safer, and that we have to always fight and continue to remember that this is not something where you pass a law and then it's done, but it's something where you have to make sure that the spirit of self-determination and individual human rights and children's rights and women's rights are honored in the application of that law, which is not what is occurring right now. And I think Jane can probably speak pretty well to that. And it's not occurring globally. It's not just a problem in one place.
Yeah. And thank you, Ruth. It very leads well into, I know Jane has plenty to share on the systems as well. And as you said, Ruth, the systems are, they mimic the perpetrator behaviors, the coercion, the power over and complying. Jane, do you have some more to add there? I know you work tirelessly in this field of the courts.
Well, not just me, there's other members within Sisters. Even today, we're at New South Wales State Parliament. We met with the Minister of Women for Women and Safety and Sexual Violence and Disabilities, I think it is, the Shadow Minister for the same, the Shadow Minister for child protection, to keep it simple for those people who may not be from New South Wales. We had Emma Hurst, who's from the Animal Rights Party, I think it is. Anyway, this key meeting today was talking about what Ruth was mentioning is that we have a system that is adversarial, and in that process of it being adversarial, the way that evidence is put before this court is in a manner that is sometimes too extreme, or minimizes to far too much, or that whole system itself. And I remember, Janine, you and I've had this conversation, is that our current system of determining the best parental processes after separation is fundamentally flawed, is critically dangerous in relation to the safety of women and children, and we need to look at something a lot different. And I'm really pleased to say that in New South Wales we are pushing for a review around how the state and the federal manage the safety of women and children. And it was an excellent outcome today. And Abigail Boyd facilitated this. She's from the Greens. And they asked a lot of questions. And it's actually really surprising to me, as someone that's done this, and you've been involved in this too for a number of years, how much they need education about what's really happening at the coalface, what's really happening with legal aid. In New South Wales, one of the things that has been something that I want to see significantly change is the way legal aid works with survivors. And they have, minimal contact. They don't get enough time, and lawyers aren't paid probably enough money to be able to manage these cases. And when it comes time to present the adversarial process, within adversarial processes, either the lawyer hasn't done their job properly, or they haven't had time to do it, or the person that is their client needed to provide information, but they didn't really know, or they didn't understand the system. So I think that as far as the systems approach to managing the safety of women and children, especially even family law and the state, needs some review. They need lived experience. I have a great, as I think Ruth sort of sees my tweets quite a lot. I have a great belief that lived experience, what people are feeling and seeing, needs to be placed on the table. It needs to be central, and we need to find ways and levers to better manage the experiences of survivors and child survivors, so that we have safer outcomes.
Yeah, I agree. And believing us is an important start. But I agree, listening to lived experience is something we're only just starting to see now, it feels like. I think there's just so many of us coming together that our voices together can't be siloed off and can't be silenced. So that leads into the next question about the barriers to safety. What are the barriers. I know thinking about just in family and friends is one of the first barriers where, you know, this used to be a taboo subject. It's steeped in shame. And do we make sure that this conversation is something that survivors feel okay to talk about? You know, it's not, we had no choice in it. We had no, it wasn't our fault. I think there's such a focus on the victim and how the victim behaves, and we need to flip that narrative onto the perpetrator and having, you know, the focus on why is he or she, but, you know, the majority, unfortunately, the statistics tell us it's gendered violence. How do we make the focus stay where it should be on the perpetrator, and then you know, the systems and the barriers to safety? You know, how do we navigate these seemingly enormous hurdles? What do you think, Betty?
Oh, that's a huge question, Janine.
Yeah.
Just starting going back, I like to work backwards from our death reviews because we're working in the area of high risk and high harm, we call it. When there's a homicide and a homicide involving children, the media always splash that around like some inexplicable tragedy, such as with Hannah Clark and the children. But we've had several of those. They're not. There has been, even with Hannah, we've had 2 inquests in Queensland recently where those victims had numerous contacts with police, agencies, child safety, on and on it went, family court, domestic violence court. And through our death reviews, we found in a 12-month snapshot that on average, a victim would have 28 contacts with service agencies prior to that homicide. The worst in that year was 58 for one, but the average is 28, where they've gone to numerous agencies. So I think the biggest barrier to start with is we don't have a one-stop shop. We don't have one door where they go and they're believed. We don't have one door where people say, I understand your risk and I understand your safety needs and I'm going to take them so seriously. The inquest for Doreen Lackman and Hannah Clark, those women were crying out to be believed. They were telling people, I think he's going to kill me. Like, what more do we need to be doing? So I think in terms of our systems, we probably have good people in all our systems, but they're not linked. We have no way of linking and charting risks. We have no way of sharing information that could save a life. And the tragedy is when we have these death reviews around Australia is we've got hindsight, but I don't want to have hindsight. I want to think that any woman who's at significant risk is going to get the help she can. And I think that, you know, often where people see safety and risk is that someone is seriously injured physically and not seeing other signs that could actually be pointers to it. But I think the barriers are absolutely huge from, you know, we were just talking about courts, but like for us and our women, and the reality is we've got women now that are juggling at least 3 courts. They've got maybe more: children's courts, family court, domestic violence court, and the criminal court on strangulation charges. Their whole lives are spent just juggling those. They've got prosecution cases that are dependent on how rich he is, whether those charges get plea bargained down. We've got, you know, on a systemic level, the lack of housing, the lack of pathways for women to really start to rebuild their lives after violence. We talk a lot about it, but we know our shelters are full with often no way of exiting out of them, that women are on wait lists for public housing. If you can't have a house, you can't have anything. You know, we can have all the best programs in the world, but if women are still living in cars with their kids, which they are, we have no, I think, sustainable programs out there for our First Nation women. You know, they're overrepresented in homicide and in hospitalisation, and they're still worn down with racism and intergenerational violence and lack of resources. Sorry, I could go on for ages, but I think the barriers are real. We had recently the summit to develop the Fourth National Plan. I was a delegate at that, and quite frankly, it was a talk fest. I think that we really didn't grapple with some of these really big issues. And as you know, Janine, it's hardly been mentioned in the election.
And
You know,
it was discussed about the summit. You know, there were very
yes.
few lived experience survivors there to help guide the conversation. So we need lived experience embedded in the next national plan. Thanks, Betty. The barriers are huge, and something that the financial barriers are huge. You know, you did say that the perpetrator he's got the money, he's got and often in the relationship there was financial abuse, and that's something that I hear from many survivors, and homelessness is a huge issue. So yeah, if you haven't got a stable home, it also plays into family court proceedings where, you know, you haven't got a home to look up to care for your children in. So leading to Jane with those barriers. What are the stop mechanisms? What can we put into place that can? I mean, I see funding for appropriate legal support as vital. Survivors are self-representing in family courts whilst they're, you know, being re-traumatized and re-abused by a system that has the exact same characteristics as the perpetrator. I see not easy, but definite responses that need to be instigated.
Well, one of the things that happens within the family law context is I've been doing this for 6 years, assisting women in family court, and I can say hands down, absolutely, and I can look at my Excel spreadsheet and say that the majority of the women that self-represent are well supported with a legal practitioner behind them, and some form of ongoing caseworker, whether it's a legal caseworker, which is what I do, or a caseworker that has some legal knowledge. The outcomes and the management of domestic violence and child sex abuse is significantly better. The outcomes are significantly better. So do we start, you know, this is about, I think what we need to be doing is start talking, what is a better model for management of the legal side of things? You know, sometimes women are far too traumatized to be able to manage their legal events, but you're the ones that can. I have seen some great results, and the court has had the information because the person who's experienced it is able to explain it. And if they can put it down on paper and they've got some coaching, I call it guided advocacy, you know, with a legal practitioner, they've been able to put it properly before the court. What I'm finding is that sometimes legal practitioners who are directly representing even legal aid, they don't want to mention the war. You know, why mention domestic violence? You're going to stop the co-parenting agenda. And you know, I think there is a shift. I'll be honest, in the process of managing domestic violence. Not all judges, in my opinion, get it, but there are some brilliant judges out there in Australia who have, in my opinion, taken on board domestic violence, coercive control, gaslighting, and they really understand those mechanisms, and you'll find precedents around that. And Heather Douglas has done some brilliant work with her DV bench book for those people who need references. I guess one of the biggest things I think when people have someone representing them is that if they're instructing their lawyer, they don't know what is available to them. And I've actually pushed for, and I'm talking to some key people about setting up what's called an academy. So the academy around scenario-based education. So what do I do when I go to court? How does initiating application work? One of the biggest questions I get on a weekly basis would be, how does alternative dispute resolution work? And what should I be doing? What type of outcomes can I get? And there's not a lot of education around that. So let's start thinking about solutions with the system that we have, and then solutions for removing an adversarial system, because as Ruth said, it's about goods and chattels. It's about the ownership, and we need to shift ourselves away from that type of model. It's not good for men, it's not good for women, and it's certainly not good for children. One of the biggest things that came out of today when people were telling their scenarios was that independent children's lawyers don't interview the children. So here they are representing the court and the children's interests, but they've not spoken to the children individually. So here we have, and I have examples of this, and I'm speaking with the permission of the mothers that I work with, children who have aged out of this system, who have such severe and significant self-harming and mental health constraints that are poorly managed. They don't have the funding to go and deal with their trauma. So that's a huge issue. But these issues around children who've had moratoriums placed on them because the court had thought that, the protective parent needs to be removed so they can rebond with the other parent, that is having significant issues. So I guess story short, our systems need review. Our systems need updating. Alternative systems need to be developed, and education, I think, sits at the heart of some of this with lived experience. And that's why I love the Safe and Together work, because it certainly covers that. Ruth has been working with the Family Court of Australia and expanding their knowledge, and I've actually seen some of that training, and it's just phenomenal to see that we are looking at coercive control. We are looking at people who use systems as abuse to women in particular, who have been traumatized, who don't know how to speak up for themselves. So I'll leave it at that. I might hand that to Ruth. Ruth, what sort of, have you found the programs that you've been running within Australia?
So I haven't personally been running them. David has been mostly the point person on the training for the Australian family courts. And, part of the strategy was that we were going to train the experts who give their recommendations to the judges, primarily and very heavily, and then move on through the court system in not just training, but also discussions about how to change policy and mandates. A lot of challenge to good practice and to holding abusers accountable are the policies and mandates that arise in these siloed systems that don't communicate with each other. So if you think about the dislocated experience of a survivor who goes to the police and then is handed off perhaps to a women's shelter, or then a call to child protection is made, or she's engaged with other services, often those services do not speak to each other. They do not gather the same information. They're not supportive of each other, and they're often very victim blaming and adversarial. One of the things that's arisen in our desire to keep women and children safe is a focus on women and children and not on the abuser and their choices as a parent and their damage to their family and their harm to their children and their continuing choices to continue their coercive control via other methods. And so what we really need to reimagine is a whole network of support around survivors, starting with friends and family who understand coercive control and the dangers of domestic violence and don't tell us to stay. Number one, that would be great. if our friends and family stepped up. So we've created the Ally Guide to try to help that. Number two is systems that are domestic abuse informed, where they have people who have been trained, not just in awareness training, not just in the signs and symptoms, that is not enough, but in actual practice of how to engage abuse survivors and their perpetrators as parents, and how to behaviorally hold them accountable and hold the line on what is acceptable and what is not. In reality, we're dealing with very large, angry, violent, powerful, and empowered children. And everybody needs to tell them that it's not okay. All of us need to stand in unison together and say, that behavior is not okay. Yes, you have lost the control of your partner, and you never should have had it in the first place, because controlling people is not a primary foundational relationship agreement that works. It destroys families. So if you're engaged in that power and control, you are not doing right by your family, you are not doing right by your children, and you are not doing right by your partner. And our singular focus should be looking at you and saying, stop doing it. Stop, or there will be consequences. Really, we can get into all the political debates we want and the system debates that we want, but at the end of the day, it's how do we behave? How do we behave as professionals in an organized way, which looks at the abuser and doesn't look at the victim and the children and say, why did you stay? Why aren't you doing this? Why aren't you responding this way? Let's send you to a drug and alcohol program because now you have an addiction, and tell you you're a bad parent, and totally ignore the fact that your abuser has either caused or exacerbated or impeded your ability to be healthy. Let's really do our jobs. Social services arose in a void of responsibility to the populations that it serves. There is no other entities in the world that serve, quote unquote, say that they serve survivors, when in reality, they don't care about our experience of their service. That is not okay.
Absolutely.
Our taxes pay for that. Our money pays for that. We pay for that. So their outcomes need to be tied to our satisfaction. Our satisfaction, not the government's beliefs in what's right, not their social theories about the family, which are often driven by perpetrators who believe that they should have power and control. But we should be able to say, what you did, your service helped me and my family become safe, stable, self-determined, and free, or what you did actually harmed me and encouraged my abuser to continue to abuse me through your service. Now, we need to not fail. It's really that simple. And across the board, social services is failing. The preponderance of their efforts does not have the outcomes that they say it does. And the data that they provide us is extremely sketchy. Child protection doesn't have to reflect back on 80% of their caseloads having domestic violence, and they don't have to give a rationale for why they didn't address the perpetrator as a parent. That's not within their mandates. And the reality is it should be in their mandates across the board. So, I'm pretty fired up about the fact that these services are dislocated from each other. They don't use the same common language. They have no mandate to be truly domestic violence informed. They get awareness training. They don't get practice training, and they don't have to communicate with each other in a way that benefits survivors, and they don't get paid. The government doesn't give them money based off of our reporting of their outcomes. They're serving us. If they're serving us, we should be the ones that say if their service is working or not.
And there should be safety. If they're serving us, there should be safety for the survivors. And yeah, thanks, Ruth. I think even thinking about survivors from family court experiences are saying that they're being told not to disclose domestic violence. That we need domestic violence informed systems where survivors aren't told, don't talk about that, or you'll likely lose your children. Don't disclose child sexual abuse. You'll definitely lose your children. We need to talk about what's really happening in the systems, and having, that should be a clear mandate that information is shared and shared amongst systems. It beggars belief, actually, but that I'm leading into the next question, probably for Betty. As Ruth led into there, these are dangerous people. We know that that strangulation, sexual abuse, separation, and stalking are the 4 key indicators, and there's many others. But as you said before, the women that have lost their lives tragically, or have had their lives taken, were begging for help, and not heard. And it harks back to a patriarchal system where, who's allowed to have a voice, who's allowed to be heard, who decides that. And as Ruth was saying, it should be the voice of the survivors that is loud and clear. And in Australia we have Section 121 of the Family Law Act that stops survivors from being able to have a voice. Basically, stops the media from reporting for fear of identifying participants of family court. I think I'm leading to Betty. We know what to do, and as you said, these murders are preventable, and I'm sure it's hugely frustrating. And it is frustrating for all of us to not be heard. How do we be heard?
That's a good thing, Janine. How do we be heard? I wrote a discussion paper in 2008 called Dying to be Heard, because victims are dying to be heard, and I believe they still are. I want to wind it back, though, well before the family court. I think that we need in place systems, whether we're talking about families, sporting clubs, workplaces, police, etc. Victims need to be heard and to be supported and to be safe well before it gets into any courts. I think that we need organisations that will take someone's safety so seriously that I keep saying, in Australia here, if as many people were being killed by sharks, we'd be draining the ocean. We'd be looking at solutions. We'd be looking to find every which way. We do work through the courts, mainly through the criminal courts at the moment. But I think by the time we get some of these perpetrators into court, we're looking way too late. I think we've got to make it that victims are going to be okay to come forward, that we allow them to shake off that mantle of shame, that the perpetrator is the one that wears that mantle. And I think we do this, as Ruth was saying, we have a focus on the wrong person all of the time. The first intervention, workplaces talk about, in our workplace, if you're violent to your partner, this is the consequences. If you're in a sporting club, I get appalled when I see domestic violence services out there doing so much with our local football clubs. Sorry if you're football supporters out there, but for goodness sake, unless a football club's going to be reformed from the inside, I don't care what they're saying on the outside. I care what organisations do on the inside. Walk the talk. And I think that we started a project out in the community of having our red benches everywhere. We've got over 300 now. And this month, we've got boys and blokes on the red bench. People keep saying to us, Betty, it's not all men. And I say, I know it's not all men. But men men who aren't violent are largely silent. And they've got to step up. They've got to speak out. They've got to challenge their work colleagues. They've got to challenge their friends. We've got to challenge the media more. The media reporting on the large for domestic violence is appalling. So I think when we're talking about making this whole environment safe for victims, it has to be holistic, and it's got to be well before perpetrators get dragging victims into courts, because that's just another arena that gives them a little bit more power. They can apply to have matters deferred. They can have, discount what she says. We've got to create this absolute intolerance to violence, towards their partners, and violence towards their children, and start to see the extent, as we know with the family court, we have that, it works on the premise that, both parents have a right to their children. They don't want to believe that violence occurs to their children. And yet we know violence is damaging to children. And the work we're doing with non-lethal strangulation and, asking the mums about it, most of those kids have been strangled. We know that a lot of victims are walking around and people are talking about they've got PTSD and they've got trauma, blah, blah, blah. They've got anoxic brain injuries. We have no research in Australia on this. We're just starting to look at that and how destructive and damaging it is when we're pulling women into the courts that are, carrying such extensive injuries. And because they can't show those injuries, they're just absolutely destroyed by those systems. So let's wind it right back. Let's teach young people about not just healthy relationships, but equal, respectful signs of violence, how to get out, where you can go, so that women support other women. And I wasn't going to bring it up, but sorry, I have to. I just get so sad when I see the number of women out there really having hurrah, hurrah parties for Johnny Depp. And I think every time you put something up on social media that says, I don't believe a victim, you're telling all victims, I don't believe you. You're not saying I'm a safe person to come to. I'm not going to believe you because I will choose who I believe. If I don't like a person, I'm not going to believe them. That's the message you're giving. And I think we've got a lot to do. As Ruth said, it's with our education and that's the attitudes that lie underneath. And, we live in a patriarchal, misogynist society, and people will go to the power. We talk about power and control. We go to the power. We don't want to rock the boat. We don't want to be the one out there leading the charge and making courageous statements against government or against the power brokers. But we need to do that if we're going to keep women safe.
Thanks, Betty. And I think it also reminds us that there's such a misunderstanding of perpetrators, and that they are pathological liars, but that they are often charming and really know how to manipulate. And I think that is where society and community really needs to be educated. They may seem like a charming, outgoing person, but that it's a for a reason. There's method behind it. So I think and Ruth's your Safe and Together Institute, the mapping the perpetrator patterns of behavior, I think that's pivotal in helping survivors to put forward their information and their evidence. And I think when we're I think the stereotype of the victim is a meek and mild broken person, and often we're not. We're rallying and railing and trying to survive. But I think when you're coherent, you must be lying if you're not coherent and you're not making sense, you're labeled with crazy. So again, it's looking at the perpetrator and supporting the victim, listening to the victim, but always putting the blame on the perpetrator and the shame back to the perpetrator. And how do we assist or stop or say, as you said, Ruth, this behavior is not okay, when in society we have so many different areas of society where power and control is looked upon as a it used to be looked upon as an important factor. So I think my question is, how do we change the narrative in our communities about perpetrators and about putting the onus on the perpetrator, so that the victim is not always the one seeking help, seeking safety. The perpetrator must be removed from that scenario before they're safe and together.
Yeah. It's a really complex question because it deals with different systems that all collide in the same space and often have really unintended consequences. I think about when I had toddlers and how I had to constantly do behavioral change with them, right? They would pitch a fit and throw themselves on the ground and scream because they couldn't have a cookie, right? And as a parent, I had to say, that's not okay. You're not going to get a cookie. No matter how hard you kick, you're still not getting the cookie. Nope, I'm not going to be manipulated by this. In a similar way, this is actually what systems need to do. So, perpetrator pattern mapping is leaving a system behind that's looked at violent incidences as their legal measure for whether or not they were going to intervene to try to make us safe. And those interventions often do not actually make us safe. Protective orders do not protect us. Some perpetrators won't kill us because there's a protective order, but those were most likely the perpetrators who weren't going to kill us in the first place if a protective order functioned in that manner for them. And so it's really important that what we do is we constantly draw people's focus back to the abuser. It's really easy to control survivors and kids and tell them what to do. And it plays right into the hands of a violent, manipulative abuser who has power and control and who's already perceived to be the rational one, whereas women are perceived to be irrational and crazy. Excuse me, I have some allergies, so I'm struggling a little bit. But one of the things that, Safe and Together wanted to do was this perpetrator mapping tool was locked behind expensive training for only professionals. And as a survivor, to me, that was unacceptable. I know that most survivors do self-represent, at least here in the United States, and they don't have the support of caseworkers like you do in Australia. And I know that those survivors are often really damaged by that and their children removed by the courts and given to an abuser, and that's the reality globally, actually. And so we embedded the guidance for the perpetrator mapping in the tool itself and included systems manipulation in that mapping tool. So if a perpetrator is using the family courts to threaten their partner with removal of custody of children for disclosing domestic violence, a professional notes that and uses that as part of their pattern of behaviors. So we're trying to be protective in a way that constantly brings people's focus back to the actions and choices and behaviors of an abuser, rather than what we've done to this point, which is try to manage the safety of women and children like we're infants who don't have the capacity to make choices if we're given good options, which we do have that capacity. And to move away from failure to protect and incidence-based practice, which really demands that women and children get harmed physically before we can ask for any interventions. And that's not acceptable. It's not acceptable to have a system that demands the physical harm of women and children before it will intervene in violence and abuse. So we really have to get away from this idea that physical violence and those singular incidents are the thing we need to focus on. We need to look at people's patterns, their choices of behaviors in the context of their relationship, their culture, and in the context of the vulnerabilities of that survivor, in the context of the systems that they're using and manipulating to extend their power and control. And all of that needs to be mapped as part of their pattern because it shows their willingness to use governmental systems of power and control to harm us. And it shows their level of potential danger. One of the reasons that I don't like checklists is because they lead to a false sense of awareness of what that perpetrator is doing. And often those checklisted items are focused on the survivor. So for example, in a risk assessment, one of the risk assessment questions is whether or not the survivor is pregnant, because data shows us that domestic violence rises during pregnancy. But the problem with that question is that it focuses on the survivor and the fact that she's pregnant and therefore she's the problem, not the person who's choosing to abuse their pregnant partner and their behaviors. So all of our focus needs to shift. We need to change our language. We need to be dealing in holding abusers behaviorally accountable. And that doesn't just mean jail. That means employers firing people who are abusing coworkers. That means the bar association disbarring lawyers and judges who are abusing because they're prejudiced and they cannot properly represent or judge those cases. That means removing politicians who have histories and patterns of behaviors of sexual violence and of violence towards women, because they're not impartial, they're not neutral, and they're not living their duty to the law.
Absolutely.
And we all need to name it
Mm.
and say it.
Absolutely. And sorry to interrupt, Ruth. When we talk about systems, systems are made up of people. You know, a system isn't some entity. It's individuals. It's people in that system, and the accountability needs to be there for those individuals, as you say, that are perpetrators themselves in the system, utilizing that system of power to harm others and to enjoy. They get enjoyment and gratification from that level of power, and to looking at the court system and the patterns of perpetrator behavior. We know, Jane, that that's a common pattern of perpetrator behavior, that repeated dragging victims through the court. The family courts don't have the same setup as the domestic violence courts, where you can have separate waiting areas, and or you can be by video link. We know that that adversarial family court system is definitely something that's used by perpetrators to continue the coercive control, and that money factor. That it can. I've spoken to people that have been in the family court system for decades. Just horrendous accounts. And where is the oversight?
Can I just add on to that, and something that you've mentioned, Ruth, and kind of you too, Betty, is that we cannot change what we don't measure. And there are a lot of things within our systems that we don't measure effectively. And while Ruth talks about the lists and mapping and sort of that type of process, and I'll give you an example, and this is kind of important. I'm very concerned in the way Project Lighthouse is working within the family court. I have clients that I'm working with that have been deemed at the risk in the EVIT list, which is the highest risk category. They have gone through that process and they've been received an email, they've had the psychological assessment, they've had the someone within the court system, a court worker, actually go through key facts. They've had those facts verified by the court, convictions of domestic violence, ADVOs, multiple issues with the children, with child protection. They've got all that evidence. But what I'm seeing is that it stops. So they get their notification and they're on the EVIT list and they hear no more. So that's just the clients that I'm working with. So what I did then, as you do, you go, oh, that's a bit strange. So what do we need to do to check that? So I worked through Jenny McAllister and asked her to ask of the family law courts, what's the statistics around those that are on the EVIT list, where the perpetrators have what type of custody do they get? How does the court process work for them? And the response that I've had from the court is that we don't measure that. So if we're not measuring that, how can we change that? And then the process then needs to be, it's part of this evolving cycle that we need to start to making our court systems accountable. But they're saying they're protecting us, but I hate to say it, they're not. And we need to look at how this is actually working, and they need to be accountable. Getting back to Ruth's point, they need to be accountable for what they say they're doing.
And yes, absolutely. And do we think that, so Queensland have committed to introducing coercive control laws. Do we think that will take perpetrators out of the family court? They'll be in the criminal justice court. How do we see, what do we need to talk about and see happening with coercive control laws to protect? I mean, we talk all the time about misidentification of the victim. It's something that happens far too often, and far too often for First Nations women. What do we need to talk about, and what do we need to put in place to make sure that the coercive control laws are initiated safely? Are we looking at the Scottish model? What are your views on the coercive control laws? Betty?
Janine, I've got huge concerns about this. I think before we get to writing laws, we need a national understanding. We don't even have a common definition. You can't write law if you don't have a definition of what you're writing the law about. So whether it's Queensland or nationally, the first thing is we've got to have a definition that we're all agreed to. I think secondly, we don't have, even though we've been lobbying for ages, for policy and practice on identifying predominant aggressor and what that is. That it's not, I'll take this order out on you, if you take it, drop it on me. And there is so much coercion, again, for victims, if an order's on them, to leave it on them. I think we've got a long way to go. We've got this review of the Queensland Police Service. Mind you, it's only going for 4 months. But, I think about accountability. It's got to go right back. What's the recruitment of the police? So I think it's not about looking at what's there now, but, what do we do with police who are perpetrators and offenders? But, Janine, I want to go right back to the bigger picture here in Australia. I always believe that the personal's the political. And if we go way back to our very first Prime Minister, the ridicule that she got, no matter what political party you subscribe to, people were out with signs, ditch the witch, drop her in the ocean. She needs to be, someone even talked about strangling her. She needs to be strangled. And there was a lot of tolerance to that. I remember being so appalled that people thought that was funny. And here we are now with Brittany Higgins and Grace Tame and the ridicule they've been getting at the highest level. If women can be sexually assaulted in our parliament, for heaven's sake, that, women, no matter where you are out there, you've got a voice. And I think that we need to have a collective voice. And I think as women, we need to stand strong on these things. I think we've got to look at what unites us, not what divides us. And I think that we've got to get a strong voice for women to say, we want more. We can't expect to be changing an individual perpetrator when they see this unfolding all around them. We see the behaviour of some of our politicians and some of our police and magistrate. And I think that unless we start to say, no, you know, this isn't okay, we want better people out there representing us, because these are the people that are making the laws. These are the people that are writing the programs and funding the programs. And if they're not the ones that can stand strong on this, then any individual challenges to perpetrators isn't going to work, because the role models that they've got out there are pretty shocking role models at the moment.
Yeah, absolutely.
Can I add something
yeah,
to that?
please do,
It's a really good point that you make, Betty, is that the ditch the witch. So in this meeting today, we had a little bit of a discussion with the politicians. They were mostly women in the group. And when they were gathering in a group of 4, some male politicians within New South Wales Parliament called them witches. That's the witches over there. That whole mentality, you know, that theme around, you know, that marginalisation, victimisation and labelling of women within our legislative framework. These are intelligent and capable women, is appalling, and bringing them to account that there doesn't seem to be much to bring those behaviours back into line, except, you know, like, and I think, you know, our men need to start saying that's not good enough, especially within our parliaments.
Yeah. Ruth, you were nodding along there.
Yeah, you know, first of all, your local political context is your local political context. And
we need more women in Parliament.
Yeah. And also, you know, Australia has a unique history, which is both beautiful and tragic, and needs to be honored in who represents survivors and how initiatives are funded and prioritized. That's something that needs to happen. The people most impacted by the system should have the biggest power sharing voice in the reform of those systems. And that's very, very important for us to hear, because many times the people who are making the laws or making the policy and legislation are not the people who are most caught up in the system. You know, I was very lucky that I was able to afford my own lawyer to defend myself against post-separation coercive control. And I was very lucky that I had resources to do that. And many, many women and many people do not. And they should not suffer because of their lack of resources. You know, I feel very strongly that this is always going to be a long-term struggle. There is no point in which we can sit back and say, we have done our jobs and we are done now. That is the exhausting reality of this. And that we have to be strategic and aware of how our systems work and actually function. And we have to work within that context to reform that context and to make it better for women and kids, and more equitable and more truly impactful and efficient and ethical when dealing with domestic abuse and child abuse victims.
And I think also, like, people, when you're saying that, I'm thinking that people don't actually understand what's happening in the systems. Like, the general public don't know that a federal court often overrides the state jurisdiction of a DVO or an AVO. So there's a huge disconnect there, and people don't know that these things are happening. So, and I see that as a, you know, as you say, it's a long-term problem, or it'll take long-term solutions, but there's a solution. One solution there is that, you know, how are how's the federal court overriding police prosecuted DVOs? Yeah.
Can I add something there? In the Family Law Act, there's a section 60 CG, which says that the court needs to, as much as possible, stay in line with the state protection orders. And unfortunately, I don't see that practiced enough. And I wouldn't be fair to say it's not practiced, but I sometimes, in the matters that I work on, which can be some terrible domestic violence matters, I don't see it utilised at all. And there's another part of the Family Law Act which says that if there's domestic violence, equal shared parental responsibility is set aside. It's section 61 DA2. So if you actually have that applied in the family court a lot more than what I see, then I think that we will have orders that are more equitable, that could be safer, especially for women and children. It's the application and what the lawyers actually fight for. You know, one of the most common things that mums say to me is, I want a lawyer who will fight for me, and you know, sometimes they don't. They just go with the status quo. They just move right along. They keep it simple, and it's like a you know, a train. You know, from a production line. You go through your production line. At the end, you've got your order. See you later. And
a very expensive production line.
That's right. That's right. But I mean, I think if we manage alternative dispute resolution a lot better than what we do, and we allow people to know what you can actually ask for in this context, one of my most common questions, and what their rights are, and what they, you know, they're able to ask for, then I think we'd have a lot more cases that weren't litigated. They are resolved. You know, there was one case recently in Canberra that went really well, where they made temporary parenting orders as consent orders and tested them to see whether it worked by agreement. And they came back, made some adjustments, and they had the final consent orders. No, you know, that type of approach, you know, maybe we need to think a bit differently.
And I'm sorry, I cut you off there, Ruth. Please continue.
No worries. I just wanted to sort of, you know, acknowledge and affirm what Jane is saying, and that is that we always think the solution is in the law and the policy. Well, there's some really good laws out there that are never applied, and there's lots of policy that's not followed. And the number one thing that continues perpetration is unaccountability. It's not anything else. It's abusers and those who abuse the law not having accountability, and there being no consequences for their actions. And so, you know, I do want to kind of circle back around to the coercive control laws. Yes, your coercive control laws will be used against survivors. Point, ended. That will happen. How do you protect them against that? Yes, survivors will be charged with coercive control. We've already seen it. We've already seen men who say, well, she yelled at me and made me feel bad, and therefore that was coercive control. When on the other side, that person had removed that woman's personal liberties and ability to have contact with family and verbally and emotionally abuse them. So we already have a system that's primed to go, "Aw," with men who feel like they're in danger, oof, but not with women who are actually in danger. So, you know, so you really do have to live in the reality that any coercive control laws passed will definitely be used against survivors. They will probably be used against more marginalized survivors in populations which already experience that harm. And that doesn't mean that not defining coercive control is a good thing for everybody, but it definitely means that we have to work really hard to understand how that happens, to resist it with all of our knowledge and skills and efforts, and also to make sure that the proper pathways for people to hold perpetrators accountable exist in multiple systems, and that those are actually functioning the way that they should function.
And what do we think so are we calling for a royal commission into you know, the institutional discrimination and misogyny, abuse of women? Is it a judicial oversight? Is it what is that mechanism of accountability and follow up to, you know, as a teacher, I see where I support a student and we look at the student as the center. It's student centric, and I see we need that in our system too, where it's survivor centric and the systems work around the survivor, and we have to make sure we've got the right survivor. Betty, I know you were talking earlier about the government, Queensland government's appointed a domestic, family and sexual violence commissioner. What do you think? Would that, how do we hold perpetrators using systems and the systems that are perpetrating abuse? How do we hold them accountable? And I'm mindful of the time too, and we've got lots of questions coming through. What is that mechanism for accountability?
That's a Commonwealth position, Janine, not state. The Commonwealth has appointed someone as a domestic violence and sexual assault commissioner. At the moment, it's quite unclear the extent of what that office might be and what the oversight mean. We have been lobbying in Queensland for a state domestic violence commissioner and their office, similar to the child protection system, the Children's Commissioner, as an external point. As I said right at the beginning, we cannot have police and other departments handling their own complaints. It needs to be done externally. I think there is a role for that. I think, you know, post-election, let's see what that Commonwealth role and their office is going to be. But I'd like to see the states pick it up. But I have been reading the questions and there's a couple. Can I just come back to a couple?
Please do.
Because they picked up on points I was saying. One was about the strangulation of children and why isn't it taken seriously? No one's talking about it. We had a webinar with a paediatrician from the US. We had child safety involved. We had police involved, and no one's talking about it. There's a few reasons, I guess, it's harder than with adults to proceed. Is firstly in Queensland, our laws, or most states, the laws regarding the protection of adults to children is quite different. The examination and medical testing for adults, again, is different. The tests that they may do for children, that proceed quite conservatively, cautiously, because of exposure to radiation and other things. They probably mightn't test as much. But we do need to put it out there. And it relates to a second point about, can we talk about the rise of pornography and sexual violence? And I wanted to talk about that in the context of strangulation and young people. That overlay between sexual assault, strangulation and pornography is on the rise. It has been for some time. It is worrying. It is worrying that young people, and I'm talking about young women, are getting groomed into participating in really harmful. You know, we're having conversations around sexual violence and consent, but there's often that mistake. They consent to sex. We're consenting to strangulation. No, you're not. You cannot consent to something that could kill you. They are two different things. Even if someone consents to sex, they're not consenting to strangulation. And rough sex gone wrong became the biggest offence to homicide in the UK, and they had to move to outlaw it. We've had, thankfully, a couple of cases in Australia, but that really worries me about, you know, well, she agreed to rough sex. Women can't agree to strangulation. There are some that think they can. They can give warning signs, they can tap out. The more you're strangled, the more harm you're doing, the more harm you're doing to your brain and to your body. So whoever raised that question, that's a good point. It is on the rise. It's on the rise with young people, and it goes way outside of any curriculum that I've seen around respectful relationships. Young people aren't even talking about relationships anymore. They're talking about hookups. They meet someone on those dating sites for one night and they find themselves in a really dangerous. So again, emerging issue that we really need to be mindful of, I guess.
Seems to be an all-round erosion of respect, yeah, that it's a cultural issue. Are there any other questions that we can address that have been in the chat? I'm just having a look, trying to have a look now.
Someone talked about the merging of the family court with the Federal Circuit Court. Just so that you know that there's still 1 and 2. There's still the 2 courts are still there. So no, they're not really merged. They're just been renamed. But what is really important, I think, is in the 1st of September last year, there was a change of rules around how the family court operated and the way that lists work, so that we have national lists as it relates to contravention. We have national lists for managing child support. So in that process of managing lists, I think there has been a better outcome in the management of cases rather than what has happened previously. But yeah, so I think that if you look at the change in the rules and the change in the way that the court is actually making decisions, the processes of making decisions, there has been, I think, some improvement, albeit small.
And some improvement is good, and I think we're coming to the end of our time. There's a last question here. Can you talk to corruption and profiteering of victims of DV by family lawyers? And we've talked a lot about tonight having and transforming the system, reimagining the system, taking out the adversarial nature and wrapping survivors in safety and support. So I think, does anyone have something quickly to add about, well, how do we add something quickly to corruption and profiteering of victims? But there is a lot of money involved in family court proceedings.
There's been an improvement, I think, because before there's a case requirement now with these new rules that a solicitor needs to project what the fees will be to run a course of action. And I think that has been an exceptionally good move for people to realise what the other side is spending on their court case, but what the cost is. So why can't you mediate out of this? So it's going to cost you $65,000. Well, what can we do to actually avoid one party spending 65 and the other one maybe 45, depending on how they're working? So I think
that's hard when we know perpetrators are doing it for a reason. There's not that ability to want to get out. It's by design. So yeah.
So the courts actually, I think, need to stop accepting some of the applications and seeing them for what they are, which is why the bench book that's been written by Heather Douglas is really good, because she talks about that. And you know, sometimes I have worked with clients to show them in the bench book so they can speak to their lawyer, how do we manage this? You know, and I think it's still coming back to that. There is certainly this cash train that happens. You know, I don't know about you, Janine, but I hear of people spending $500,000 on court, or running out at beyond that. And they've been in court for 8 years, and it's just some gravy train that, you know. So again, I still come back to, we need an alternate non-adversarial model to be dealing with some of this, or try to, you know, experimenting on like a pilot of some description where we can test ways of dealing with separation.
And that one stop, one door, you know, where the survivor is the one at the center, and the systems or the practices are talking to each other, not siloed off, linking systems, communicating systems, and having accountability. Accountability is probably my takeaway from tonight, and the survivor's voice. I think Betty, you talked about Brittany Higgins was instrumental in highlighting the sexual violence in Parliament House, in the workplace, Grace Tame in institutions, but we know that the most dangerous place for women and children is in their own home. And that is something that I fear that the Australian public's just not ready for, but we must have this conversation, and we must talk about the systems being used to continue that control and to put those stops in place. Are there any other questions that we see that we really want to?
And then can I just say, to pulling back again, from we can't only look at, I guess, the profiteering in the family court. The work we do in the domestic violence court and the criminal court, and I'm not talking at all about corruptions, it's the way our justice system works. Everyone's entitled to their day in court and everyone's entitled to justice. But victims often become players in that, and I would suspect actually more victims are in the criminal courts than they are in the family court. If you look at the number of breaches, Queensland has just record numbers of breaches, and once someone's charged with a breach of a protection order, then it's the Crown prosecuting that case and the victim becomes a witness. And that is such an abusive process. They're often not informed of what's happening. They're not informed of court dates. They've got to repeat statements months and months after the fact. They're not well prepared. And at the end of the day, if he's got a wealthy barrister that's going to fight it, what prosecution will often do is look at what's in the public interest. Is this in the public's interest to fight this? And they will try and plea bargain down to lesser offences, or they'll say, we can't win this. And often of a victim, we see it in sexual assault charges when they're out, putting their, I guess, self and sanity and everything on the line to get justice. And we say to them, it's not a justice system, it's a legal system.
Yep.
And because you're not a guilty verdict doesn't mean it didn't happen to you. It just means that's how the justice system or the legal system worked. So that profiteering is not just there, but I wouldn't say it's corruption. I'd say it's how that system works against victims.
Absolutely. Well, I think we might need to wrap it up there. This webinar is available after tonight, and all of that information will be shared amongst all of our members that came along. Thank you so much, Betty and Ruth and Jane, for your knowledge and your time and your passion. It's wonderful to see such change happening, and it gives me such hope for the future and for safety. And I think that central point of community not tolerating this behaviour anymore is so important to keep repeating. So thank you, everyone, and thank you to Brad, Sash, and Edward Carroll for facilitating tonight, and the Australian Progressives for facilitating tonight. We look forward to much more change in this area and safety for women and children. Thank you, everyone. Lovely to see you.
Thank you.
Talk again soon.
Thank you.
Recording.